A lot of people believe that once you obtain a certificate of occupancy, you have arrived, your land is safe and secure, and no one can take it from you. Well, news flash, it is not exactly like that, because the C of O is not the only way to prove title to land. I had promised to make this video last week, but I've not had the time to look put together, to look very organized for it. So I don't want to keep postponing. So ignore whether I look tacky or disorganized and just get the message. So now let's begin. Since the enactment of the Land Use Act in 1978, the C of O is now the standard title document that is issued in land registry as a way of proving title to land. It is official, it is legal. But there are other documents that can be considered valid when it comes to proving title to land, such as the land certificate or registered conveyance that were in use before the enactment of the Land Use Act. Those ones, as long as they were legal or they were in use before the coming of the Land Use Act, which now makes the C of O official, they are still very valid. There's also something called the deemed right. Basically, it's talking about the customary owners of land, the historical owners of land, before the coming into force of the Land Use Act. That one too is considered to be valid. So someone who has a deemed right of occupancy, even when they have not officially applied for a C of O, they have a valid title to that land. But that method of proving title to land is subject to certain conditions and can be reviewed by the legal authorities. So yes, I've mentioned 3 different ways that you can prove title to land apart from C of O: land certificate, registered conveyance, deemed right of occupancy. So where you obtain a C of O and no one has come out to counter with a better title, then it raises the presumption that you are the owner in exclusive possession. However, if someone who has a better title to that land, like someone who has a land certificate that was in effect before the coming of the Land Use Act in 1978, or a registered conveyance that was in force before the coming into force of the Land Use Act, or someone that has a deemed right of occupancy, then it is possible that your C of O may be revoked. Now, let me read to you what the Supreme Court had to say on this matter. A certificate of occupancy properly issued where there is no dispute that the document was properly issued by a competent authority raises the presumption that the holder is the owner in exclusive possession of the land. The certificate also raises the presumption that at the time it was issued, there was not in existence a customary owner whose title has not been revoked. So which means that your C of O, your proof with that C of O is rebuttable where someone with a better title comes forward. So don't just think that you have won the crown and you are the exclusive owner. Be careful. For example, you have a C of O and then someone else comes out to say, this land is our land. We've been living on that land, or we've been living in that space since 1970. Remember that the Land Use Act is 1978. We've been living in that place since 1970. We even built a house. That person can successfully prove ownership that is more superior to your C of O title, as long as they begin this litigation within 12 years since the cause of action arose. So it is time bound. So if you bought that land and you got C of O, after 12 years, someone with a better title cannot come out and claim against you. It is time bound. So except you want to be praying to God that nobody should fight you or come out and drag the land with you in the next 12 years, it's not even worth the stress. What you need to do is due diligence. So you have to do your homework. You have to get a lawyer to do the due diligence for you so they can find out the history of that land, if there are any previous owners, and if there is no encumbrance on the land. You need a lawyer to do that for you. I've said this over and over again in my previous videos. There are other ways that you can lose your land even with certificate of occupancy, but this video is already getting too long and I don't want to bore you. So I'll make another video explaining other ways that you can lose your land even with your C of O. The summary of today's gist is that before you buy land, do your due diligence. There might just be someone out there who has a registered conveyance or a land certificate, or who is even a deemed someone who has a deemed right of occupancy, and you don't want to find yourself in that situation. And also ensure that you are working with professionals. Get a lawyer to do the due diligence for you, to do the search and the investigation for you, so that you do not fall victim. Because you will hold your C of O in your hand like this, and hot tears to be flowing. And I'm sure you do not want that. I hope you learned something from me today. If you did, please follow my page if you're seeing this on Facebook, and subscribe to my channel if you're seeing this on YouTube, and share this video with somebody. Someone definitely needs it. Thank you very much, and enjoy the rest of your day.